copyright law, like all laws, is super complicated. But luckily, this actually is not about laws at all. It's about the delicate and beautiful dance of negotiation. But I do want to say that this is the reason that you can never decide to represent yourself in a serious legal matter. It's always worth it to get a lawyer to read through the minutia of these laws, because I'm going to try and explain the copyright legal situation to you as best I can, but there's a lot of details in there. If anyone happens to be a copyright lawyer, feel free to weigh in down below. But as I said, this is really a business discussion, and we love those. So I'm talking about the headline on Friday that was meant to scare you, as at least Mark Toberoff, the lawyer representing the creators, hoped that it would. They want you to freak out, man. Very much like Sony wanted you to freak out that Marvel, the MCU, might lose the right to use Spider-Man. And remember how I told you that that was not going to ever be a problem? Because both parties benefited so much from the MCU being able to use Spider-Man, and that it was just Sony trying to get a better deal by leveraging that threat? Same exact thing is happening here. Because Disney has already shown back in 2014 with the Jack Kirby lawsuit, with the same exact lawyer, by the way, if it ain't broke, don't fix it. This guy's he gets a cut of these settlements, by the way. But they settled with Jack Kirby. They settled with him in 2014, a couple of years after the lawsuit was brought. So getting into a legal fight with Disney ain't pretty. Again, this is why you need a lawyer, and you're going to see, how this is going to come about. But anyway, after getting Jack Kirby a lawsuit, Toberoff now sees a new crop of creators that he can threaten Disney with. He got the Kirby estate a one-time payout of about, the rumor is $30 to $50 million. We're going to talk about why a one-time payout is preferable to the points forever that you would think these creators would want. So once Toberoff says, haha, I got you, Disney Marvel, why doesn't Disney Marvel just immediately settle, right? Why make all of us nervous? Because as I said, this is the dance. This is not only the dance of negotiation, but the reason they're doing this dance is to see who has more leverage in negotiating said settlements. Who has the upper hand? It's always Disney. Whoever has the most lawyers, unless the law is firmly on your side. But I think there's some question to that, as you're going to see from the Kirby case. Basically, they tried to take it to the Supreme Court. We'll go through it. But, I don't think that there's a open and closed shut case for the creators here. So that's why, again, a settlement is ideal. So first off, Disney ain't gonna pay nobody nothing unless they have to. That's usually the way most people work. So Toberoff, again, he's made a career out of finding Silver Age creators who signed the very loose freelance contracts of the 1960s comic book industry. By the way, the comic book industry to this day is one of the most unprofessional industries that exists. It is shocking. For instance, talent still is not represented by agents in the comic book business. You need to know someone to get a gig. When they want someone to write one of the marquee comics, they tend to be like, who's my friends? Would you like to write a Batman comic? It's ridiculous. That's why I think that, speaking of leverage, the comic book industry has so little leverage when it comes to going up against Hollywood. Still today, even with that unprofessionalism, when you sign a contract with any company, but especially because now Disney and Warner Brothers lawyers are involved with the big comic book companies, who owns what is now ironclad. But it was not in the 1960s. So back to Toberoff. He goes over to Disney and he says, hey, thanks to these shoddy contracts, my clients, thanks to these shoddy contracts and copyright law, which Disney helped negotiate to protect their older copyrights. So Disney's Disney not only is very involved in copyright law, but that means they're also very involved in copyright law and they know it backwards and forwards. But creators have a window where they're able to go back in and say, hey man, I want a cut of this. It's been like X number of years. It's favorable to creators. So that's what's happening. So that's what they're saying, that they want to cut. They don't get the whole character back outright. But the problem is that they not only would get a cut, but they would able to, in some other countries where contract law is even more favorable to creators, be able to hypothetically license these characters out to other companies. Like the Hollywood Reporter had a good article on this, and they said Canada. What movies are they making in Canada? I think they're not going to do something like that, but maybe there's a Canadian company and they want to slap, I don't know, Thor or Loki on one of their lunch products. Something like that is what you have to worry about. But that's a silly threat, because Toberoff, clearly a smart guy, if he were to win in court and get this this percentage back for his clients, he would just march right back to Disney and say, okay, how much are you going to pay me for them to lock these characters up 100%? Why would anybody get involved in these drawn out legal battles with trying to market it off to other characters for far less, to other companies for far less than Disney will pay to avoid the headache? But Disney doesn't want to do that because Toberoff would have the upper hand and they'd have to pay him quite a bit of money. And that's also why they don't say, okay, you got us, Toberoff, here's your settlement. Disney, and all companies, but especially Disney. Disney is a super cheap company. They want to pay as little as possible, which just goes to show you how much these characters are worth, by the way, considering Kirby walked away with 30 to 50 million, and that's Disney giving them as little as they possibly could. So they need to go and challenge him in court to make his odds look pretty freaking bleak of winning if he were to pursue this. And then they can give him a lowball settlement offer and come at it with a number that they're a little more comfortable with. At the end, again, this is how it goes. If you want to get a couple tens of millions of dollars, you got to hire a lawyer. They got to roll up their sleeves and they got to slap each other around a little bit over there. All right, so Disney, I think, will likely pay out settlements in the same 30 to 50 million range they paid Kirby almost a decade ago, and before Disney Plus and theme parks made these characters even more valuable. So I'm sure that Disney is nervous about that too. They're like, we're not paying inflation rates on that. I think they're like, Kirby got 30 to 50. You should be happy with that too. And that's another reason they're playing hardball in the courts to scare the estates of the creators and be like, it might take you a decade to see any money from us. So maybe you'd like this settlement. So what they're arguing is that these are work for hire gigs, no matter how loose the contract might be. But still, Toberoff, by pushing this case to the Supreme Court, was able to hold off that counter argument because he was willing to go to the Supreme Court. Now, Disney settled before the Supreme Court even decided if they would take the case. And you might say, well, maybe Disney will be willing to go to the Supreme Court this time around because the court has become more conservative. But these days, conservatives are pretty anti-Hollywood, and Disney's not going to take that risk. Disney's not going to let someone else decide what happens to their characters. I don't even know if Toberoff will have to threaten to go to the Supreme Court this time. I think, again, a couple of months, they'll write some checks. And so Disney, because there's a couple of creators this time, might end up giving out hundreds of millions of dollars with a one-time payout. But that's better than having to pay a percentage of the profits for these characters forever and the headache of calculating said profit across the entire Disney empire, especially as they start to hide profits more and more behind the great digital wall, which everybody's complaining about. Now, yes, those percentage points forever would result in a lot more money. So you might be like, hold out, Toberoff, get the percentage points. But who knows how long you'll be in litigation with the Mouse's army of lawyers. You'll have to argue with Disney forever also about what those profits are that you deserve a cut of. I mean, there's very creative bookkeeping in Hollywood, if you can even get access to the numbers these days. So that's going to be a headache. So you're dealing with people who are like, I'd like to personally see these tens of millions of dollars. I'll take the one-time payout. And that's the way it's probably going to go. Toberoff has a loss, though, on his side, representing the heirs of Superman creators Jerry Siegel and Joe Shuster, but that's because their heirs had already settled with DC in the past. Now, here's where it gets interesting. Now, under copyright law, which, again, Disney itself helped amend to protect its older copyrights, the copyright itself goes up in 95 years. We're talking about ownership, who gets a cut of what. Now, what about when these characters enter the public domain? That's Disney's real problem, or any company's problem. But Disney has some of the oldest copyrights. That means Spider-Man, for instance, who first appeared in 1962, could become public domain in 2057. That sounds ridiculous. Don't worry, it is. Or more interesting, Mickey Mouse is supposed to become public domain in 2024, or next year, Winnie the Pooh. What? But while the copyright might expire, Disney has these things trademarked up the wazoo. For instance, that's how Edgar Rice Burroughs' estate has locked down Tarzan, even though that copyright has expired. Because these just aren't creations, these just aren't characters in some book, they are representations of huge empires and products and businesses. Their money is being made off of. And trademark law is a lot more ironclad than copyright law. So some folks sure will be like, the copyright expired, it's in the public domain. But then Disney will just slam them so hard with their legal team that they will see cartoon, stars. So that's basically what's going on. I think there's some people have a fantasy that it'll be in public domain, we'll get our hands on it. Keep dreaming. It's never going to happen, So that's the situation. But I don't know. I don't really think that's fair. I mean, Disney makes so much money off of Mickey Mouse, something, and in these other characters that they either created or did outright purchase. I think it would be ridiculous for them to go into the public domain. And you see some things like you'll be like, how is this movie uploaded on YouTube? The other day, I was watching Ghosts. And a friend of mine said, this is like Topper. And I was like, oh my God, it is like Topper. And I discovered that the original Topper movie with a baby Cary Grant in it is on YouTube because it's in public domain now. But that's because nobody wants to fight for the rights of Topper. The only things that slip into the public domain are things that no longer have any value. So if there's value to be had, someone's locked those rights up. All right, share your own thoughts about this down below. Again, don't worry. What do you think of the dance, though? What do you think of and also the unprofessionalism of the comic book industry? Subscribe today, and of course, as always, you can check out some more videos right now.